So when is a guardianship needed? Now we're going to get down to the nitty-gritty. How do I know my child needs a guardian? This is the question you have to answer. Can the proposed the standard Judge Wolk has to answer is the proposed ward cannot make or communicate significant responsible decisions concerning their health or safety. Lots of vague words in there, isn't there? You know, what
Welcome
exactly?
Welcome to my world. Welcome to my world.
That is the standard in Georgia. That right there is the whole thing. If your child cannot make or communicate significant responsible decisions concerning their health or safety, they need a guardian. If they can, they might still need a guardian. Conservatorship, this is the same thing as a guardianship, but it's dealing with property. The proposed ward cannot make or communicate significant responsible decisions concerning their property. What's not written in the law, but is assumed, and they have property. If they don't have any assets in their name, you don't have to ask for conservatorship. In fact, I know some judges.
Now, let me step on you a little bit, because there is a divergence. I will tell you that there is a divergence within the state of Georgia between the probate judges. Some of them say if you don't have property, we won't, even if you ask for it, we won't appoint a conservator of the property. Some of them do sort of a conservatorship in reserve in case any money comes in. I will do a conservatorship where there are no funds because of the contract issue. Because I have seen situations with identity theft running as rampant as it is, contracts being signed just because, believe me, you guys have watched the news, just because you don't have money doesn't mean you're not going and signing contracts on boats and those kinds of things. So I have seen enough situations where I think having a conservatorship on file, even though there are no funds available, removing the right to contract and indebt themselves and potentially financially harm themselves, to me justifies creating a conservatorship. That's my conclusion in my interpretation of the law, is that removing those rights is a sufficient reason, even if there's no money to manage. I cannot, if you don't live in Cobb County, I cannot speak to what the probate judge in your county's policy and procedure is on that. But just to put you all on notice that that is a bit of a difference of opinion.
Is property considered any assets or physical property?
It is.
Or assets, money, that what little they do make? Or
it is income.
Wild uncle might will to them, not knowing that.
And that's where you get into the standby, where they put the conservatorship on reserve. If some of them will do it in anticipation of a potential inheritance, but typically, if you're talking about assets, it is income, property, which lay people define as real property, dirt, and then there's personal property, which is what lay people define as stuff, and then there are bank accounts, and assets, which is what lay people define as money. And so you've got pretty much anything of value is going to count as an asset. So what you get into, and this is a very real difference as well, what you get into is when you've got disability benefits, you've got an income stream. So that is in fact something that's being managed. If it can be managed as a rep payee, then there may or may not be any, if you're the representative payee, it's actually coming to you for the benefit of. And so there are differences of opinion, again, sorry to not be able to give you very standard answers, but there are differences of opinion if the only asset is an income stream and you are rep payee, whether or not the probate judge will enter a conservatorship.
And I've now done guardianships in 10 different counties in front of 12 different judges, and I think there are about 15 different opinions on this.
Yes, and they're legitimately different opinions, because one of the downsides, and Mark's going to get into this, I know, but one of the downsides of this is typically you have to post a bond if you're a conservator, and you have to file an annual return, which costs $75-ish a year.
And it's a hassle.
Yeah, and you have to, you essentially have to recreate a year's worth of a checkbook register. And so you don't.
For the person or for you?
For the proposed proposed wards, or the proposed, I guess they're the ward at that point,
Yeah.
of the ward's money. So anything that's come in, sort of what you're doing for Social Security and all of that, but you have to do it for us too, and it's a separate pleading. And so there are reasons that you might not want to have a conservatorship if you feel, again, what's likely, what's possible, what's probable, all of those things. If it's very unlikely that your kid's going to be in a situation where they can go out and sign a contract, then this may not, the hassle factor of filing with us every year may not be worth it. But if they are a person who is out in the community, high functioning, may get on dating websites, may do these things, you know, this may then become something where you want to remove those rights, and you can just walk back and say, here's your car. You should have known better than to sell it to somebody who had a conservatorship, and you're legally deemed to know what's on file in the probate court, so you should have known better than to do this.
And I've had success nullifying contracts just with the guardianship, because the guardianship order specifically, there's a little place y'all initial that says the right to enter into contracts is removed with the guardianship. Mm-hmm. But when it comes to talking to credit reporting agencies and things like that, they're probably looking at, okay, do you have the financial power, which is the conservatorship, to clear up a credit record.